procedure cannot be provided by the Parliament to override that procedure. That is the argument made. What is your answer to that?
My Lord, I totally bow before that observation, but my submission is that only to the extent of legislative competence, the Parliament has the domain. The Parliament, in principle, can provide for a law regulating the review, but not the practice and procedure. Otherwise, the term Parliament or Majlis Shura should have been used in 191, which is not the case, my Lord. This is my first submission. And Honorable Justice Jamal Khan Mandukhail had the
आप चलिए आप अपना आगे केस आर्ग्यू करें.
my Lord, question.
Other point.
Other point is that, my Lord, this conferring of domain or competence, legislative competence upon the Majlis Shura without having a specific item number in the federal legislative list or the substantial part of the Constitution, it means we are giving the Parliament a power which it did not have, and that has broader implications for the federation and the federal structure, my Lord. Lordships would appreciate that father of the nation wanted a federal state, and he wanted autonomy of the federating units. We are, my lords, interwoven in a very delicate and complex relationship. And what guarantees the autonomy of the federating units is the fact that there is a federal legislative list, there is no provincial legislative list, and the concurrent legislative list is gone. So anything which is neither in the federal legislative list nor in the substantive part of the Constitution is a provincial matter, my Lord. So, if this honorable court gives the Parliament the power to enact on a subject which may not be there in the federal legislative list or the substantive part of the Constitution, at the garb of item number 57 and 58, or at the garb of incidental and ancillary powers, it means that the Parliament may encroach upon the provincial subjects.
पहले नेक्स्ट पॉइंट, ये तो आर्ग्यूमेंट अजीब सा है. तो आपका कहना है कि 4 सूबे अपने अपने कानून बना सकते हैं.
No, ये नहीं है मेरा.
तो ये आप यही कह रहे हैं?
No, my lord, no, my lord. Residuary matters. There is no provincial legislative list.
हमें पता है ना, इस कानून की बात करें ना.
My lord, it has implications. It has implications, and these are not remote implications. These are immediate implications.
अगला पॉइंट बताएं.
So the submission is, the prime submission pertains to the legislative competence or the legislative incompetence of the federal legislature, my lord. My second submission is that, and it was pointed out by Honorable Justice Musarati Lali in the form of a question.
Please, direct argue करिए.
My lord, answers भी तो brief मैं time नहीं लूँगा. That apparently, by virtue of the act in question, the office of the Chief Justice has been done away with. It has been abolished for all practical purposes, my lords. And lordships would appreciate that as per definition given by Article 176.
Before you say this, first say which provisions of the Constitution create the office of the Chief Justice, which has been abolished.
My lord, 176 defines the Supreme Court, which says that the Supreme Court shall comprise of the Chief Justice and judges, as many judges as determined by the Parliament or Presidential Act. So the institution stands on 2 limbs, office of the Chief Justice and judges, my lord.
आपकी अगर ये बात मान ली जाए तो आप कहते हैं कि चीफ जस्टिस और जजेस अलग-अलग नहीं है, एक ही है.
My lord,
और अगर एक ही है तो फिर क्या चीफ जस्टिस अकेले रोस्टर बना सकता है?
My lord, रोस्टर बनाने से पहले मैं एक अर्ज कर लूँ, my lord. we hear that the Chief Justice is senior among equals. While sitting in the judicial capacity,
Let's not go over.
My lord,
Point आप बताएं ना अभी
point पे
ऐसी-
आ रहा हूँ, my lord. While sitting in judicial capacity, he is equal among the equals.
आगे बढ़िए आगे बढ़िए हाँ।
What makes him senior among equals is administration. Now, what has been done through this?
There are certain powers specifically bestowed on the Chief Justice in the Constitution.
May I refer to them, my lord?
Yes, there's some powers have been specifically bestowed on the Chief Justice.
Thank you, my lord. I'm referring to them. Some of the powers, my lord. Article 183(2).
पढ़ लें. The specific mention is of Chief Justice.
Seat of the Supreme Court, Clause 2. The Supreme Court may from time to time sit in such other places as the Chief Justice of Pakistan, with the approval of the President, may appoint. It is the...
This is destructive of your argument. Here the Chief Justice has been given this power, not the Supreme Court.
Yes, my lord. Yes, my lord, because it is at the administrative powers. It is the indication that the Chief Justice is the master of the rules. He is a pater familias. This is the first indication.
ये लफ्ज इस्तेमाल हो रहे हैं मगर ये आइन में नहीं है,
आइन
केस लॉ में है सारे.
आइन में यह है कि Chief Justice on his own, without any consultation, without any recommendation of the committee, shall appoint the place of sitting.
Correct?
Yes,
because
my
the
lord.
Constitution says so.
So administratively, the Chief Justice has at least some say. While the Impugned Act, मैं दूसरे provision पे आता हूँ, my lord.
बेंचेस के हवाले से वकील साहब विद द अप्रूवल ऑफ प्रेसिडेंट
Yes.
सर्किट बनते हैं ना,
Yes,
ये
yes.
उसके हवाले से
हाँ.
और ये कॉन्स्टिट्यूशनल प्रोविजन है, इसके लिए रूल की जरूरत नहीं.
Yes, my lord. No rule is required.
इसका
But
नोटिफिकेशन होता है.
yes, my lord. Yes, my lord. But under the Constitution,
इस सिलसिले में नहीं है जो आप बात कर रहे हैं.
तो
Yes,
बेंच
my-
बनाने का पावर है, बेंच का पावर विद द अप्रूवल ऑफ प्रेसिडेंट होगा
With the
और
approval
उसके
of-
लिए रूल तो वही अप्लाई होंगे जो ऑलरेडी पहले से रूल इन फोर्स है. ठीक है ना?
exactly, my lord, exactly. But now, Article 10, Clause 1, Roman 1, Federal Review Board. Article 10, 1, 10,
10(1).
1, Roman 1, after the explanation in the bottom.
आर्टिकल 10 का.
जी हाँ, भी Chief Justice का जिक्र है.
In the case of a person, is that before your lordship? In the case of a person detained under a federal law, a board appointed by the Chief Justice Pakistan and consisting of a chairman and 2 other persons, each of whom is or has been a judge of the Supreme Court or a High Court. Now, for all practical purposes, this is a bench to be constituted by the Chief Justice of Pakistan, my lord.
This is not bench of the Supreme Court. This is not a bench of the Supreme Court. This
Not
is
stricto
administrative,
sensu.
not a tribunal.
But a forum is appointed by the Chief Justice.
We are
Mere
talking
appoint,
about the bench constitution, composition of the benches of the Supreme Court.
मैं एक अर्ज कर रहा हूँ, जो पॉइंट मैं बता रहा हूँ वो ये है कि अंडर द कॉन्स्टिट्यूशन इन द एडमिनिस्ट्रेटिव मैटर्स द चीफ जस्टिस इज ऑन द ड्राइविंग सीट. नाउ आई एम रेफरिंग टू आर्टिकल 146(3), 152, 159,
146.
clause 3. This is only for reference. I'm not reading, my lord. 146(3),
जी.
152 and 159, clause 4.
152.
152 and 159, clause 4. Under these provisions,
152 or 150.
9(4).
जी.
Under these provisions of the Constitution, the Chief Justice is empowered to appoint an arbitrator in certain fiscal matters, in certain disputes, my lord. Now, under the original Constitution, prior to the 22nd Amendment, the Chief Justice was empowered to appoint a caretaker, Chief Election Commissioner, out of the judges of the Supreme Court. Under the original Constitution, prior to the 17th and 18th Amendment, the Chief Justice alone acted as a consultee for appointments in the judicial.
What is the point you're making?
My point is, my lord, that when we say that the Chief Justice is senior among equals, what distinguishes the Chief Justice from the judges administration. Otherwise, the Chief Justice would be equal among equals.
Okay, but you are saying that because these specific provisions of the Constitution specifically mention Chief Justice, so by analogy, he has other powers as well. That's what I've understood from your
Yes, no,
argument.
by analogy,
ठीक,
he is
then-
the senior among equals.
Okay.
And you see where there is a power under 191 to frame rules, the rules are for the purposes, administrative purposes. And in addition to the rules, there are constitutional or there are conventions of the court which have invariably been followed since since the 1956 Constitution, and before that the Government of India Act. So those conventions have also acquired the place of rules, or for that matter, the procedure of the court.
Yes, my lord, Article 268(7) is very much clear to that extent, that anything having the force of law has been deemed as law, my lord.
268(7).
268(7), my lord. Now, what this law has done, the law does not say